The moment the judge looked at me, my daughter-in-law stopped smiling. I remember thinking how strange it was that a room filled with polished wood, neatly stacked files, and quiet whispers could feel colder than the night my husband died. I sat there, hands folded in my lap, my back straight, my breathing steady, while across the room, my own son avoided my eyes. David had always been like his father when he was young, gentle, thoughtful, the kind of boy who would carry groceries without being asked and call just to check if I'd eaten dinner. But that morning, seated beside his wife Rachel, he looked like a stranger wearing my son's face. Rachel, on the other hand, looked perfectly at ease. Her posture was relaxed, her chin slightly raised, her lips curved into a smile that didn't quite reach her eyes. It was the same smile she wore at the will reading 3 days earlier, the day everything began to unravel. That afternoon had started with soft lighting, polite condolences, and the faint scent of lilies arranged along the walls of the attorney's office. My husband, Thomas Collins, had been gone for exactly 10 days. 10 days of quiet mornings, untouched coffee cups, and a house that felt too large for one person. I had spent 42 years beside that man. I knew the rhythm of his footsteps, the way he folded his shirts, the exact moment he would reach for my hand during long car rides. Losing him didn't feel like something that had happened. It felt like something that kept happening, over and over again, every time I turned around expecting to see him. The will reading was supposed to be simple. That's what Daniel Harper, Thomas's longtime attorney, had told me when he called. Just a formality, Margaret, he said. Nothing unexpected. I believed him. I walked into that office wearing the navy dress Thomas always said made me look steady. His word, not mine. Rachel complimented it when I arrived, her voice warm, almost affectionate. You look wonderful, Margaret, she said, placing a light hand on my arm. I remember thinking how kind that was. How considerate. I remember thinking maybe I had been too hard on her over the years. That maybe, just maybe, we could find a way to be a family again. That thought lasted less than 15 minutes. Because as soon as Daniel finished reading the final paragraph, as soon as the words primary beneficiary settled into the silence of the room, Rachel leaned forward slightly, her expression sharpening in a way that felt almost practiced. David shifted beside her, clearing his throat. And then he stood up. I can still hear the sound of his chair scraping against the floor. It was louder than it should have been. Or maybe everything just felt louder in that moment. We're contesting the will, he said. Just like that. No hesitation. No softness. No acknowledgement that he was speaking to his mother. The room went still. Daniel blinked, clearly caught off guard. I didn't move. I didn't ask questions. I didn't even look at David right away. I kept my eyes on the table, on the grain of the wood beneath my fingertips, as if studying it closely might help me understand what was happening. We believe there were irregularities, Rachel added, her tone smooth, almost gentle, as if she were explaining something minor, something reasonable. Margaret may have influenced Thomas in his final months. That was the moment I looked up, not because of the accusation itself, but because of the certainty in her voice. She didn't sound unsure. She didn't sound like someone making a claim. She sounded like someone stating a fact. David nodded beside her, his jaw set, his gaze fixed somewhere just past my shoulder. He still wouldn't look at me. We've already filed the paperwork, he said. Our attorney will be in touch. I remember nodding. Just once. A small, controlled movement. The kind you make when you're acknowledging a detail, not when your entire life is shifting beneath your feet. I didn't argue. I didn't defend myself. I didn't remind him of the nights I stayed up when he was sick as a child, or the years Thomas and I spent building everything we had from nothing more than careful decisions and quiet sacrifices. I simply folded my hands together and said, I understand. Rachel smiled then. Not a wide smile. Not a triumphant one. Just a slight curve of her lips, like someone who had been waiting for that exact response. That was 3 days ago. 3 days of phone calls I didn't answer, of messages I didn't return, of a house that felt different in a way I couldn't quite name. It wasn't just emptier. It was clearer, like something had been removed that I hadn't realized was there. And now, sitting in that courtroom, I could see it all with a kind of quiet precision. The polished shoes, the neatly pressed suits, the way Rachel leaned toward their attorney, whispering something that made him nod confidently. They believed they had already won. That was the part that almost made me smile. Not because I found it amusing, but because I finally understood something Thomas had tried to tell me years ago, something I hadn't fully grasped at the time. People show you who they are when they think there's nothing left to lose, he had said once, late at night, his voice calm, almost reflective. Back then, I thought he was talking about business, about deals and contracts and the kind of things he handled with quiet competence. I didn't realize he was talking about something much closer to home. The judge adjusted his glasses and looked down at the file in front of him. Then he looked up at me, and in that moment, something shifted. Rachel's whispering stopped. David straightened in his chair. The room held its breath, because whatever they thought they understood about me was about to change. I did not look away when the judge held my gaze, but I also did not speak, because I had learned something in the last 3 days that had taken me years to understand, and that was this: silence reveals more than words ever could, especially when the people across from you are waiting for you to break, to defend yourself, to explain, to justify, because that is when they feel strongest, when you are trying to prove something they have already decided is not true. So I simply sat there, my hands resting gently against each other, my shoulders relaxed, and I let the room settle into its own tension. And in that stillness, my mind drifted back to the morning after the will reading. The first morning I woke up in that house knowing my own son had decided I was no longer to be trusted. I remember the light coming through the kitchen window in that quiet way it always had, soft and pale, touching the same countertops Thomas had installed himself nearly 20 years ago. I made coffee, out of habit, measuring it the way he liked, even though I was the only one there to drink it. And I sat at the table where we had spent so many mornings talking about ordinary things, grocery lists, weather forecasts, the small details that make a life feel steady, and I stared at the empty chair across from me. Not because I was expecting him to be there, but because it was the only place that still felt honest. Everything else had begun to feel altered, like a photograph that had been edited just enough to make you uneasy without knowing exactly why. My phone had been on the table beside me, lighting up every few minutes with messages I did not open, numbers I recognized, voices I could almost hear without answering. But I did not reach for it, not once. Because there was a clarity in that silence that I had not felt in a long time, and it was not comforting, but it was precise, like looking at something under a bright light and finally seeing its edges. By noon, I found myself standing in Thomas's study, a room I had rarely entered alone while he was alive, not because I was not allowed, but because it had always felt like his space, his way of keeping the world organized, everything in its place, everything accounted for. The desk was exactly as he had left it, papers stacked neatly, a pen aligned parallel to the edge, a small framed photograph of the two of us taken on a trip to Maine years ago. I picked it up, not to dwell on the memory, but because I needed to steady my hands, and that was when I noticed the drawer, slightly ajar, just enough to suggest it had been opened recently, which did not make sense, because I had not touched it, and neither had anyone else, at least not that I knew of. I pulled it open slowly, not with urgency, but with intention, and inside, beneath a folder labeled in Thomas's careful handwriting, I found an envelope, thick, sealed, my name written across the front in the same deliberate script I had seen for decades. Margaret, no embellishment, no explanation, just my name. I sat down before opening it, because something about the weight of it told me this was not casual, not something he had forgotten to mention, and when I finally unfolded the paper inside, I did not feel shock, I did not feel confusion. I felt something much quieter, something like recognition, as if a part of me had always known this existed, even if I had never seen it before. The document was not a letter, not in the traditional sense. It was structured, precise, with references to accounts, to dates, to legal terms I did not immediately understand but could feel the significance of, and at the bottom, his signature, steady and unmistakable. I read it once. Then again, slower the second time, letting each line settle, and with each sentence, the picture became clearer, not just of what he had done, but of why he had done it. Thomas had never been a man who acted impulsively. He planned, he observed, he waited until he understood the full shape of a situation before making a move, and now, sitting in that quiet room, I realized he had been doing exactly that for years, not out of suspicion, but out of preparation. He had seen something I had chosen not to see, something in the way Rachel spoke, in the way David began to defer to her in small decisions, in the way conversations shifted subtly over time, and instead of confronting it directly, he had built something beneath the surface, something that did not rely on trust, but on structure, on protection. I folded the document carefully and placed it back into the envelope, not because I wanted to hide it, but because I understood now that timing mattered, that revealing something too soon could be just as dangerous as never revealing it at all. The rest of that day passed quietly. I moved through the house with a kind of deliberate calm, not rushing, not hesitating, simply observing, and in the afternoon, I noticed something else, a change in the way the accounts appeared when I logged into the shared system Thomas and I had used for years, small details, nothing dramatic, but enough to suggest someone had attempted to access information they were not fully entitled to. I did not react. I did not call anyone. I simply logged out and closed the laptop, because by then, I understood that whatever was happening was not new. It was only now becoming visible, and visibility, I was beginning to learn, was the first step toward control. So, when I received the official notice of the lawsuit later that evening, delivered with all the formality such things require, I did not feel the sting I might have felt before. I read it, noted the language, the claims, the careful way it framed me as someone who had taken advantage of a vulnerable man, and I set it down beside the envelope with my name on it. 2 documents, 2 versions of the same story, and I knew, even then, which one would matter when the time came. So now, sitting in this courtroom, with Rachel watching me closely and David still unable to meet my eyes, I did not feel like someone defending herself. I felt like someone waiting, and when the judge leaned back slightly in his chair, his expression shifting in a way that suggested he had just noticed something others had not, I knew that moment had arrived. The judge did not speak immediately, and that silence stretched across the courtroom in a way that made every small movement feel amplified. The faint rustle of paper, the quiet shift of someone adjusting in their seat. Even the soft click of a pen being set down seemed louder than it should have been, and I could feel Rachel watching me from across the room, not with concern, not even with curiosity, but with calculation, as if she were trying to measure how much I understood, how much I knew, and whether I was about to become a problem she had not prepared for. David sat beside her, his shoulders slightly tense now, his fingers loosely interlocked as if he were trying to appear composed, but I noticed the way his thumb moved against his knuckle, a small habit he had when he was nervous, something he used to do as a child when he was about to admit he had broken something. And for a brief moment, I wondered if he remembered that, if he recognized that the same quiet signals were still there, still visible to someone who had spent a lifetime noticing them. But I did not let that thought linger, because this was not about who he used to be. This was about who he had chosen to become. The judge adjusted the papers in front of him, his expression thoughtful rather than reactive, and when he finally spoke, his voice was calm, measured, the kind of tone that did not rush toward conclusions. "Mrs. Collins," he said, looking directly at me, "your son and his counsel are claiming that you exerted undue influence over your late husband in the drafting of his will." I inclined my head slightly, acknowledging the statement without reacting to it, because there was nothing in that claim that required an immediate defense. "Not yet," the judge continued. "However, there are additional documents referenced here that I would like clarification on." And that was when I noticed the subtle shift in Rachel's posture. It was small, almost imperceptible, but her shoulders tightened just enough to betray a flicker of uncertainty. Her attorney leaned forward, glancing quickly at the file in the judge's hands, as if trying to anticipate what was about to be said, and I realized then that whatever the judge was seeing, it was not something they had fully accounted for, and that realization did not bring me satisfaction. It brought me focus, because moments like this were not about emotion, they were about timing, about allowing the truth to unfold at its own pace. Rather than forcing it into the open too quickly, my mind moved back, not to the will reading, not to the moment David stood up and declared his intentions, but to something earlier, something quieter, a conversation Thomas and I had shared nearly 2 years before his passing. It had been late, the house dim except for the lamp beside his chair. He had been reviewing documents, something related to the business he had stepped away from years earlier, and I had asked him, almost casually, why he still kept such detailed records when everything had already been settled. He had looked at me then with that same steady expression he always had when he was about to say something important without making it sound dramatic. Because things are only settled until someone decides they are not, he said, and I remember smiling at the time, thinking he was being overly cautious. But now, sitting in that courtroom, I understood that he had not been speaking about business at all. He had been speaking about people, about the way intentions can change when circumstances do, about the way relationships can shift when something valuable is placed between them, and more importantly, about the necessity of preparing for that shift before it happens. The judge turned a page slowly, his eyes scanning the document in front of him, and then he looked up again, this time not just at me, but briefly at David and Rachel as well. It appears, he said carefully, that your late husband established a separate legal structure several years prior to his passing, one that designates specific conditions regarding the distribution and control of certain assets. Rachel's expression did not collapse. It did not break in any obvious way, but I saw the moment her confidence faltered. It was in the way her lips pressed together slightly, in the way her gaze flickered for just a second toward her attorney, as if seeking confirmation that this was still within the bounds of what they expected. David, on the other hand, looked confused, not alarmed, not yet, but uncertain, like someone realizing that a conversation they thought they understood had just taken a turn they did not anticipate. I remained still, because this was not the moment to speak, not the moment to explain. The judge continued. This structure includes provisions that limit access under certain circumstances, particularly in cases where there may be disputes regarding intent or influence. He paused then, allowing the words to settle, and in that pause, I could feel the weight of what was being revealed beginning to take shape in the room, not as a dramatic revelation, but as a quiet shift in balance, the kind that does not announce itself loudly, but changes everything nonetheless. Rachel leaned slightly toward her attorney, whispering something I could not hear, but I did not need to hear it to understand what it meant. They were recalculating, adjusting, trying to determine how this new information fit into the narrative they had constructed, and whether that narrative could still hold. I thought about the envelope again, about the document Thomas had left for me, about the way he had anticipated not just a disagreement, but a challenge, a direct attempt to override what he had carefully put in place. And I realized that he had not simply prepared for this moment. He had designed it, not in a way that sought conflict, but in a way that ensured clarity when conflict inevitably arrived. The judge set the document down, his gaze returning to me. Mrs. Collins, he said, I would like to understand your awareness of this structure and your role within it. And for the first time since he began speaking, I allowed myself to shift slightly in my seat, not as a reaction, but as a signal that I was ready. Because this was no longer about waiting. This was about stepping forward at precisely the right moment. And as I lifted my eyes to meet his, I knew that whatever they thought this case was about, whatever story they had prepared to tell, it was no longer the one that mattered. I did not rush to answer the judge, because rushing would have meant reacting, and reacting was exactly what they expected from me. Instead, I allowed a brief silence to settle between his question and my response, not long enough to seem evasive, but long enough to make it clear that my words would be chosen, not spilled. I was aware of it. I said finally, my voice steady, even, carrying just enough weight to be heard without needing emphasis. My husband did not hide things from me. He simply chose the right time to explain them. The judge nodded slightly, not in agreement, but in acknowledgement, as if he understood that there was more behind that sentence than I had said. Rachel shifted in her seat again, this time more noticeably, her fingers tightening around the edge of the table for just a second before she released them. Her attorney leaned closer to her, whispering something quick, something corrective, but I did not look at them, because I had learned that attention is a kind of currency, and I was no longer willing to spend it on people who had already decided my value. The judge glanced down at the document again. Can you explain your role within this structure, Mrs. Collins? He asked, and this time I did not hesitate, not because I felt urgency, but because I felt clarity. I am not just a beneficiary, I said. I am the controlling party under the conditions my husband established. There was a subtle shift in the room at that. Not dramatic, not loud, but enough that you could feel it, like a change in air pressure before a storm. David's head lifted slightly, his eyes finally meeting mine for the first time that morning. And in that brief moment, I saw confusion there, not anger, not betrayal, just the beginning of understanding that something had been built without his knowledge. Rachel's expression remained composed, but the edges of that composure were beginning to show strain. The judge continued. "And what conditions are those?" he asked, and I folded my hands again, not out of nervousness, but out of habit, the same habit I had when I needed to keep my thoughts aligned. "The structure activates full control in the event of a dispute regarding intent," I said, "specifically if any party challenges the legitimacy of my husband's decisions or attempts to override them through legal action." I paused then, not for effect, but because the next part mattered. At that point, all discretionary access is suspended, and authority consolidates under my direction until the matter is resolved. The judge leaned back slightly, considering that, his expression thoughtful, analytical, as if he were placing each piece of information into a larger framework. Rachel's attorney straightened, clearly, recognizing the significance of what had just been stated. "Your Honor," he began, "we would like to review the full documentation of this structure, as this was not disclosed in the initial probate filings." His tone was controlled, but there was a tightness to it now, a recognition that the ground beneath their argument was not as stable as they had assumed. The judge nodded. "That will be arranged," he said, then turned back to me. "Mrs. Collins, when did you become aware that this provision might be relevant?" And for the first time, I allowed myself to reference the timeline directly, not to defend myself, but to clarify the sequence of events. "The morning after the will reading," I said, "when I reviewed my husband's documents in detail, I did not mention the envelope specifically, not yet, because I understood that information has a rhythm, and revealing everything at once disrupts that rhythm. Instead, I allowed the statement to stand on its own, simple, factual, sufficient." David shifted in his seat again, his expression tightening now, the confusion beginning to give way to something more complex, something that looked like realization layered over regret, but I did not let myself interpret it beyond that, because this was not about reading his emotions. This was about maintaining my position. The judge nodded slowly, then looked toward the opposing counsel. "It appears," he said, "that the initiation of this lawsuit may have triggered provisions that alter the control of the assets in question." He paused, allowing that to settle, which raises questions about the basis of the claim itself. Rachel's attorney opened his mouth as if to respond, then closed it again, recalibrating, adjusting, because the argument they had prepared was no longer aligned with the structure now being examined. Rachel leaned closer to him again, her voice low, urgent, but still controlled, and I could see now that her confidence was no longer effortless. It required maintenance, it required effort, and that effort was beginning to show. I thought back again to Thomas, to the way he had explained things not in dramatic declarations, but in quiet, deliberate statements that only revealed their full meaning over time. He had not built this to punish anyone. He had built it to protect something, not just assets, but intent, the intent behind years of work, of decisions made carefully, of a life constructed with purpose. And now that intent was being tested, not in theory, but in practice. The judge set his pen down, his attention returning fully to the matter at hand. "We will need to examine the complete structure and its implications before proceeding further," he said, his tone firm but not final. "But it is clear that this case involves more than a simple dispute over inheritance." He looked at David and Rachel briefly, then back at me, and in that moment, I understood that the narrative they had brought into this room was no longer the one guiding the proceedings. It had been replaced, not by argument, not by emotion, but by something far more difficult to challenge, something structured, documented, and already in motion long before any of us sat down at this table. And as I sat there, still, composed, I realized that for the first time since this began, I was not being asked to defend what was mine. I was being asked to explain what had already been secured. The judge's words did not echo. They settled, slowly and deliberately, like something placed exactly where it belonged. And in that stillness, I could feel the balance in the room continuing to shift, not dramatically, not in a way that would make headlines or raise voices, but in the quiet, unmistakable way that control changes hands when facts replace assumptions. Rachel was no longer leaning back in her chair. No. longer composed in that effortless way she had been when this began. She was upright now, alert, her attention fixed on the documents in front of the judge as if she could will them to say something different, something that aligned with the version of events she had built so carefully. Her attorney had already begun flipping through his own files, faster now, less methodical, searching for something that might restore the footing they had lost. David sat between them, his posture rigid, his hands now clasped more tightly than before, and for a brief moment, I saw him glance toward Rachel, not for guidance, but for reassurance. And when he did not receive it, when she did not meet his eyes, something in his expression shifted again, not fully, not enough to undo what had already been set in motion, but enough to suggest that the certainty he had carried into this room was beginning to fracture. I remained still, not because I was unaffected, but because I understood that movement. Even small movement can be misread in moments like this, and I had no intention of allowing my composure to be interpreted as anything other than what it was, clarity. The judge turned another page, his attention moving carefully across the lines, and when he spoke again, his tone was unchanged, steady, precise. "Counsel," he said, addressing Rachel's attorney. "Given the existence of this structure and its conditional provisions, I would like you to clarify the basis upon which you are asserting undue influence." There was no accusation in his voice, no challenge, just a request for explanation, and yet the effect was immediate. The attorney straightened, adjusted his tie slightly, a gesture so small it might have gone unnoticed under different circumstances, but here, it carried weight. "Your Honor," he began, his voice controlled, measured. "Our position is that Mrs. Collins exercised influence over her husband during a period of vulnerability, resulting in a distribution of assets that does not reflect his independent intent." The words were familiar, rehearsed, structured in a way that had likely sounded convincing in preparation, but now, placed against the framework the judge had just outlined, they seemed less certain, less anchored. The judge nodded slightly, as if acknowledging the argument without accepting it. "And how do you reconcile that claim with the existence of a pre-established legal structure that appears to anticipate and address precisely this type of dispute?" he asked, and there it was again, not confrontation, not dismissal, but a question that required alignment between narrative and evidence. Rachel's attorney hesitated, just briefly, before responding. "We would argue that the structure itself may have been influenced or that its conditions do not override the fundamental issue of intent." His tone remained professional, but the edges of confidence were no longer as smooth as they had been moments earlier. Rachel leaned toward him again, her voice low, urgent, and this time I saw it clearly, not just tension, but calculation under pressure, the kind that comes when a plan must be adjusted in real time. David did not lean in with them. He remained where he was, his gaze now fixed on the table in front of him, and I wondered, not for the first time, at what point he had stopped asking questions and started accepting answers that were given to him. The judge turned his attention back to me. "Mrs. Collins," he said, "did your husband ever discuss the purpose of this structure with you in relation to potential disputes?" And this time, when I answered, I allowed a slight shift in my tone, not emotional, not defensive, but reflective. "He did not speak in terms of disputes," I said. "He spoke in terms of certainty." I paused, letting that word settle, because it mattered. He believed that clarity should exist before conflict, not after. The judge considered that, his expression thoughtful, and I could see that he understood the distinction, that this was not a reactive measure, not something created in response to pressure, but something built with intention long before any challenge had been made. Rachel's attorney interjected again. "Your Honor, we would request a temporary suspension of any enforcement of these provisions until a full review can be conducted." His tone was careful, strategic, seeking to slow the process, to create space where control could be regained. The judge nodded slightly. "That is a reasonable request," he said, then added, "However, the existence of the structure itself and its activation conditions cannot be disregarded in the interim." And just like that, the line was drawn, not in a dramatic declaration, but in a measured acknowledgement that what had been set in motion was not easily undone. Rachel leaned back slightly then, her posture adjusting, recalibrating, but the ease was gone. replaced by something more deliberate, more controlled. As if every movement now required intention, David finally looked up again, this time not at me, but at the judge, and there was something in his expression that had not been there before, not just uncertainty, but the beginning of understanding that the situation was not what he had been told it would be. I thought again of Thomas, of the way he had moved through situations without raising his voice, without forcing outcomes, trusting instead that structure, when built correctly, would hold under pressure. And as I sat there, listening to the measured exchange between the judge and opposing counsel, I realized that this was not the moment of resolution, not yet. This was the moment where the illusion of control began to dissolve, where the narrative they had constructed was no longer sufficient to carry the weight of the facts now present. And in that quiet unraveling, I felt something settle within me, not triumph, not relief, but alignment. The kind that comes when what you know and what is being revealed finally begin to match. And as the judge set his pen down once more and prepared to move the proceedings forward, I understood that everything from this point on would no longer depend on what they claimed, but on what had already been established long before they ever decided to challenge it. The judge's acknowledgement did not end the tension in the room. It refined it, narrowing it into something sharper, more focused, and as the proceedings continued, I could feel the attention shifting away from broad accusations and toward specific details, the kind that cannot be easily reshaped once they are spoken aloud. Rachel's attorney adjusted his approach, his voice steadier now, more deliberate. Your Honor, even if such a structure exists, it does not eliminate the possibility that its creation or execution was influenced, he said, carefully choosing each word. We are requesting a full evidentiary review of the circumstances under which these documents were prepared. The judge nodded once, not in agreement, but in recognition of the request. That will be considered, he replied. However, the existence of pre-established conditions that directly address disputes of this nature is not insignificant. He turned slightly, glancing again at the file before him, then back toward the room, and in that moment, I understood that the case was no longer moving forward in the way Rachel had intended. It was no longer a simple matter of casting doubt. It had become a matter of reconciling that doubt with a framework that had already anticipated it. David shifted again beside her, his movements less controlled now, as if he were trying to find a position that felt stable but could not quite settle, and for a brief second, his eyes met mine, not with accusation, not even with defensiveness, but with something quieter, something uncertain, and I held that gaze just long enough to acknowledge it before letting it pass. Because this was not the moment to revisit what had been lost between us. This was the moment to remain exactly where I needed to be, composed, present, and aligned with what I knew to be true. The judge's attention returned to me once more. Mrs. Collins, he said, you mentioned that your husband explained this structure to you in terms of certainty. Can you elaborate on that? And this time, I allowed myself to draw slightly from memory, not in a way that introduced emotion, but in a way that clarified intent. He believed that clarity prevents conflict from becoming chaos, I said. He did not want decisions to be interpreted after the fact. He wanted them to be understood before they were ever questioned. I paused briefly, then continued. He knew that once something of value becomes the center of attention, people begin to see it differently, and he wanted to make sure that what he built could not be reshaped by that shift in perspective. The judge listened carefully, his expression unchanged, but attentive, absorbing not just the words, but the reasoning behind them. Rachel's attorney interjected again, his tone measured but firmer now. Your Honor, intent can still be influenced, regardless of structure, he said. We intend to demonstrate that the late Mr. Collins may not have been acting entirely independently in the final stages of his decision-making. The statement hung in the air for a moment, and I could feel the weight of it, not because it was new, but because it was the foundation of everything they had brought into this room. And for the first time, I responded directly to it, not emotionally, not defensively, but clearly. My husband did not make decisions in stages, I said, my voice even. He made them in full, after considering every possible outcome. I did not raise my voice, I did not emphasize the words, but I saw the way the judge's attention sharpened slightly, the way Rachel's posture stiffened again, because what I had said was not an argument. It was a correction, and corrections, when grounded in consistency, are difficult to dismantle. The judge leaned back slightly, his fingers resting against the edge of the file. There is also mention here, he said, of additional documentation that outlines the scope of authority granted under this structure. He looked at me again. Have those documents been submitted to the court? And this was the moment I had been waiting for, not because it would change everything instantly, but because it would begin to reveal the full shape of what Thomas had put in place. They have been prepared, I said, and my counsel has copies ready for submission. I nodded slightly toward Daniel Harper, who had been seated quietly to my left, observing the proceedings with the same calm focus he had always carried. He reached into his briefcase without urgency, retrieving a set of documents that had been organized long before we entered this room. And as he placed them on the table, sliding them forward with deliberate care, I saw Rachel's expression change again, not dramatically, not enough for anyone unfamiliar with her to notice, but enough for me to recognize that this was not part of the sequence she had expected. Her attorney leaned forward immediately, his attention fixed on the documents, his earlier composure now replaced with a more active form of concentration, as if he were trying to anticipate what each page might contain before it was fully examined. David did not move. He simply watched, his gaze following the motion of the papers as they were handed to the clerk, and for a moment, I wondered if he was beginning to see what had been there all along, not hidden, not concealed, but simply unspoken, because it had never needed to be spoken until now. The judge accepted the documents, flipping through the first few pages with practiced efficiency, his expression remaining neutral, but focused, and as the quiet sound of paper turning filled the room, I felt something settle again, not an ending, not a conclusion, but a progression. The next step in a process that had been set in motion long before any of us had taken our seats. And as I sat there, still and composed, I understood that this was no longer about defending my place. It was about allowing the structure Thomas had built to do exactly what it was designed to do. Hold, even under pressure, even when challenged, even when the people who challenged it believed they had already won. The sound of paper turning continued for a few seconds longer than anyone seemed comfortable with. Each page the judge reviewed, adding weight to a silence that no one attempted to break. And I noticed the way Rachel's attorney leaned slightly forward, his posture no longer relaxed, his attention fully fixed on the documents as if trying to read them from a distance, anticipating what might be revealed before it was spoken aloud. Rachel herself remained still, but it was no longer the stillness of confidence. It was controlled, deliberate, the kind that comes when movement risks exposing uncertainty. David sat beside her, his gaze lowered again, not in defiance, not in resistance, but in quiet absorption, as if he were beginning to understand that this was not a conversation he had fully been part of, that decisions had been made around him rather than with him. And that realization was settling in slowly, piece by piece. The judge paused at one page longer than the others, his eyes scanning the text with a level of focus that drew the entire room into that moment. And when he finally looked up, his expression had shifted, not dramatically, but enough to signal that what he had just read was not routine. Counsel, he said, directing his attention toward Rachel's attorney. These documents outline not only the structure previously referenced, but also specific clauses regarding the consequences of initiating legal action against the estate. There was a brief pause, just long enough for the implication to begin forming in the room, including the suspension and potential forfeiture of certain interests. The words were delivered evenly, without emphasis, but their effect was immediate. Rachel's attorney straightened fully now, his earlier composure replaced by a more active tension. Your Honor, we would need to examine the full context of those clauses before any interpretation is made. He responded, his tone controlled but no longer effortless. The judge nodded slightly. Of course, he said, but their existence is clearly relevant to the current proceedings. Rachel's fingers tightened briefly against the table again, a small, involuntary movement that she quickly corrected, but not before it revealed the shift beneath her calm exterior. She leaned toward her attorney once more, her voice low, urgent, and this time there was no mistaking it. This was no longer strategy. This was adjustment under pressure. David did not lean in with them. He remained still, his gaze now fixed on the documents in front of the judge, and I saw something in his expression that had not been there before, not just confusion, but the beginning of recognition, the kind that comes when a story you believed starts to unravel in front of you, revealing something more complex beneath it. I remained where I was, my posture unchanged, my hands resting lightly together. Because this moment did not require reaction, it required presence. The judge turned another page, then another, his movements steady, deliberate, and when he spoke again, his tone carried a subtle shift, not in volume, but in clarity. "It appears," he said, "that your late husband anticipated the possibility of a direct challenge to his decisions and established conditions that would alter the distribution of assets in such an event." He looked briefly toward Rachel and David, then back to the documents, including provisions that reassign control and limit access for those initiating the challenge. Rachel's attorney opened his mouth to respond, then paused, recalibrating, because the argument he had prepared was no longer aligned with the structure now being examined. "Your Honor, we would argue that such provisions may be subject to review if they are found to be punitive rather than protective," he said, choosing his words carefully, and I recognized the shift in strategy. From denial to reinterpretation, from dismissal to containment, the judge considered that, his expression thoughtful. "That determination will require a full review," he replied. "But at this stage, the court must acknowledge that these provisions exist and may have been activated by the actions taken." There was a quiet stillness after that, not empty, but dense, filled with the weight of what had just been established. Rachel leaned back slightly, her posture adjusting again, but the ease was gone, replaced by something more deliberate, more measured, as if every movement now required calculation. David finally lifted his head, his eyes moving from the judge to the documents, then, slowly, to me, and this time, he did not look away immediately. There was something in that gaze, something unspoken, something that did not belong to the narrative that had brought him here, and I met it without hesitation, not to challenge it, not to interpret it, but simply to acknowledge that it existed, because acknowledgement, I had learned, can sometimes say more than explanation. The judge set the documents down, his attention returning fully to the room. "We will proceed with a detailed review of these materials," he said, "and determine their applicability within the context of this case." His tone was firm, not final, but directional, setting the course for what would come next. And as I sat there, listening to the measured progression of the proceedings, I realized that the structure Thomas had built was not simply holding, it was unfolding, revealing itself piece by piece, not all at once, but in a sequence that aligned with the very challenge it had been designed to withstand. And in that unfolding, I felt something settle within me once more, not relief, not satisfaction, but certainty, the same quiet certainty Thomas had spoken of, the kind that does not need to be declared, because it is already embedded in what has been prepared, long before anyone decides to question it. The judge's final words in that moment did not conclude anything, but they redirected everything, and as the clerk began organizing the submitted documents for formal review, I could feel the shift settle deeper into the room, not as a reaction, but as a recalibration. Rachel no longer leaned forward, no longer whispered as frequently. Instead, she sat back with a stillness that looked composed at first glance, but lacked the ease she had carried earlier. It was the kind of stillness that requires effort, the kind that comes when someone is no longer certain where the ground is. Her attorney had begun making notes now. Quick, precise movements across the page, not the measured preparation from before, but adjustments, recalculations, attempts to rebuild a strategy that no longer fit the structure it was meant to challenge. David remained quiet, his posture no longer rigid, but unsettled, as if the tension that had held him upright was beginning to disperse without offering him a place to rest. And I noticed something in the way he looked at the documents again, not as something to win, but as something to understand, and that difference, small as it was, mattered more than anything he had said since this began. The judge turned slightly toward Daniel Harper. "Counsel, I would like confirmation regarding the timing of these documents," he said, and Daniel, calm as always, responded without hesitation. "The structure was established approximately 3 years prior to Mr. Collins's passing, Your Honor," with subsequent updates filed in accordance with standard legal procedures. His tone was steady, factual, offering no room for interpretation beyond what was already documented. The judge nodded, making a brief note, then asked, "And the conditions regarding activation, were those amended at any point following the initial filing?" Daniel shook his head slightly. "No, Your Honor. The activation conditions have remained consistent since their original drafting." There was a pause then, not empty, but deliberate, as if the judge was allowing the timeline to settle into the broader context of the case. And in that pause, I saw Rachel's attorney glance toward her again, a quick exchange of understanding passing between them, not spoken, but clear. This was not something recent, not something that could be easily framed as a last-minute decision influenced by proximity or circumstance. This had been in place long before any of the events they were relying on had occurred. The judge leaned back slightly, his fingers resting together. "That timeline is significant," he said, not as a conclusion, but as an observation that carried weight. Rachel's attorney responded carefully. "We acknowledge the timeline, Your Honor, but we maintain that intent remains a central issue." And I recognize that tone, not as confidence, but as persistence, the kind that continues forward even when the path is no longer clear, because stopping would mean conceding something they were not prepared to release. The judge nodded once more, then turned his attention back to me. "Mrs. Collins, did your husband ever indicate that this structure was intended to address concerns specific to any individual?" The question was precise, and I understood its purpose immediately, not to assign blame, but to determine scope. "No," I said, my voice even. "He never framed it around individuals, only around circumstances." I paused briefly, then added, "He believed that people change when circumstances do, and he wanted the structure to respond to that change, not to predict it." The judge considered that, his expression unchanged, but attentive, and I could see that he understood the distinction, that this was not targeted, not reactive, but anticipatory, designed to function regardless of who stood on either side of it. Rachel shifted slightly again, her composure intact, but more deliberate now, every movement measured, every glance controlled, and I realized that she was no longer trying to guide the situation. She was trying to contain it, to prevent further loss of ground. David, however, did not share that control. His gaze moved between the judge, the documents, and finally to me again. And this time, there was something clearer in it. Not accusation, not defense, but recognition, the kind that arrives quietly, without announcement, when the narrative you have been following no longer aligns with what you are seeing. And I held that moment without reacting, because it was not something that could be forced or accelerated. It had to unfold on its own. The judge set his pen down once more, his attention returning to the room as a whole. "At this stage," he said, "the court recognizes that the existence and timing of this structure introduce factors that must be carefully evaluated before any determination can be made regarding the claims presented." His tone was firm, not final, but directive, establishing that the case was no longer proceeding along its original trajectory. Rachel's attorney nodded, acknowledging the direction, though the tension in his posture remained, the kind that does not dissipate easily once it has taken hold. And as the proceedings began to transition toward the next phase, the clerk organizing documents, the attorneys preparing for further review, I remained where I was, unchanged, not because nothing had shifted, but because everything had, and reacting to that shift would have meant stepping out of alignment with the very structure that was now unfolding. I thought again of Thomas, not of his absence, but of his precision, the way he had built things not for immediate impact, but for sustained integrity. The way he had trusted that if something was constructed correctly, it would not need to defend itself loudly, it would simply hold. And as I sat there, watching the room adjust to a reality it had not anticipated, I understood that this was not a moment of victory. Not yet. This was the moment where the illusion of certainty on the other side had begun to dissolve completely, leaving behind only what could be supported, what could be demonstrated, what could withstand scrutiny. And in that clarity, I felt something settle within me once more, not relief, not satisfaction, but a quiet, steady awareness that whatever came next would no longer be shaped by what they believed, but by what had already been set in place long before they chose to challenge it. The courtroom did not empty, but it changed subtly, as if the air itself had been adjusted to accommodate a new reality, one where certainty no longer belonged to the loudest claim, but to the most grounded structure. And as the judge called for a brief recess before the next phase of review, the quiet movement of people standing, gathering their notes, and stepping away from their seats carried a different tone than it had earlier that morning. Rachel rose slowly, her posture still composed, but no longer effortless, her movements now deliberate, as if each one required consideration. Her attorney leaned close to her immediately, speaking in a low, focused voice, the kind that is not meant to be overheard, but still carries the weight of urgency. I did not try to listen. I did not need to, because the shift in their posture said enough. They were no longer advancing. They were recalculating. David stood a moment later, more slowly, his chair making a soft sound against the floor. And for a brief second, he hesitated, as if unsure whether to follow Rachel or remain where he was. And in that hesitation, I saw something that had not been there before, not confusion alone, but distance. The kind that forms when someone begins to realize that the path they chose was not entirely their own. I remained seated for a moment longer, allowing the room to move around me, not out of reluctance, but out of awareness. Because sometimes the most important thing is not where you go next, but what you observe before you move. Daniel placed a hand lightly on the table beside me, a subtle signal that we would step aside as well, and I nodded once. Rising with the same measured calm I had carried throughout the proceedings, we moved toward a quieter corner of the room, not isolated, but removed enough to speak without interruption. They did not expect this, Daniel said quietly, his tone steady, not triumphant, but precise. I met his gaze briefly, then looked back toward the center of the room where Rachel and her attorney were now in deeper discussion. No, I replied. They expected a reaction, not a structure. Daniel allowed a faint, almost imperceptible nod, as if confirming something already understood. The judge is taking this seriously, he said. That matters. I did not respond immediately, not because I disagreed, but because I understood that what mattered was not the moment itself, but what it would lead to. He is following the documents, I said finally, not the narrative. Daniel's expression remained composed, but there was a slight shift in his posture, a recognition of the distinction. That is exactly where we need to be, he said. And for a moment, we stood in silence, not uncomfortable, not uncertain, but aligned. The kind of alignment that does not require constant affirmation. Across the room, I saw David step away from Rachel and her attorney, just a few steps, not far, but enough to create space. He looked around briefly, then his gaze found me, and this time, he did not look away immediately. There was hesitation there, something unformed, something that did not yet have words, and I held his gaze just long enough to acknowledge it, not inviting, not dismissing, simply present, because whatever was happening within him was not something I could guide. It had to unfold on its own. Rachel noticed the shift a moment later, her attention snapping briefly toward David before returning to her attorney. And in that brief glance, I saw something sharper, not fear, not yet, but awareness that control was no longer complete. The recess did not last long, and soon the quiet signals of movement began again, people returning to their seats, documents being gathered, the room settling back into its structured order, but it was not the same order as before. The balance had shifted, and everyone could feel it, even if no one spoke it aloud. I took my seat again, my posture unchanged, my hands resting lightly together, and I noticed that David sat differently now, not leaning toward Rachel, not mirroring her posture, but sitting more upright, more separate, his attention divided, his certainty no longer singular. Rachel remained composed, but the ease was gone entirely now, replaced by a focused stillness that suggested control maintained through effort rather than instinct. The judge returned, taking his seat with the same measured presence as before, and as the proceedings resumed, his tone carried a subtle shift, not in authority, but in direction. We will continue with the review of the submitted materials, he said, his gaze moving briefly across the room before settling back on the documents in front of him, and addressed the implications of the conditional provisions in relation to the claims presented. There was no urgency in his voice, no dramatic escalation, but there was clarity, a defined path forward that no longer aligned with the assumptions that had brought this case into the room. Rachel's attorney nodded, his posture composed but attentive, prepared now for a different kind of argument, one that required alignment with the structure rather than an attempt to override it. And as I sat there, listening, observing, I realized that the moment of confrontation had already passed, not in a single statement, not in a dramatic reveal, but in the gradual, deliberate unfolding of what had always been there, waiting to be seen. And in that realization, I felt something settle within me once more, not victory, not relief, but understanding. The kind that comes when the outcome is no longer determined by what is said in the moment, but by what was built long before the moment ever arrived. When the judge leaned forward again, the room followed him without realizing it, as if every person present understood that whatever came next would not simply continue the case. It would define it. His hands rested lightly on the documents that had already shifted the balance of the entire proceeding, and when he spoke, his voice was as measured as before, but there was a new precision in it, the kind that comes when uncertainty has been narrowed into something that can finally be addressed directly. Having reviewed the submitted materials, he said, the court recognizes that the legal structure established by Mr. Collins was not only valid in its formation, but explicitly designed to govern circumstances such as the one currently before us. There was no reaction at first, no visible movement, but I could feel it, the way the air changed when a conclusion begins to take shape. Rachel did not move, but her stillness had become rigid now, no longer controlled, but held in place. Her attorney sat upright, his attention fixed entirely on the judge, no longer searching, no longer recalculating, but listening, because there was nothing left to adjust. David sat very still, his hands resting flat against the table, his gaze lowered, not avoiding, but absorbing, as if each word was settling into a space he had not prepared for. The judge continued. The timing of this structure, its consistency over several years, and its clearly defined activation conditions indicate that it was not a reactive measure, but a deliberate and anticipatory one. He paused briefly, allowing that distinction to settle. Furthermore, the initiation of legal action contesting the intent of the decedent appears to fall within the conditions that trigger a reassignment of control, as outlined in the documents. Rachel's attorney shifted slightly, as if preparing to respond, but did not interrupt. Because there was no opening yet, the judge turned a page slowly, then looked up again, this time directing his attention more evenly across both sides of the room. This does not immediately resolve all aspects of the case, he said. However, it does establish that the control of the assets in question has, by the terms set forth by Mr. Collins, transferred under the conditions that have now been met. The words were not dramatic, not forceful, but they carried a finality that did not require emphasis. Rachel's composure broke in the smallest possible way, a slight tightening of her jaw, a shift in her breathing that she quickly attempted to steady. But it was there, unmistakable, the moment where control is no longer assumed, but questioned. Her attorney leaned toward her, speaking quietly, but this time there was no immediate response from her, no quick adjustment, only a brief stillness as the meaning of what had been said settled in. David did not look at her. He remained where he was, his gaze now lifting slowly toward the judge, and then, almost involuntarily, toward me. And in that moment, there was no confusion left in his expression, only realization, the kind that arrives without warning and does not ask permission. I did not react to it. I did not move, because this was not a moment that required acknowledgement. It was a moment that required stillness. The judge continued. Given these findings, the court will proceed with a detailed evaluation of the remaining claims, but any assertion of undue influence must now be considered within the framework of a structure that was clearly designed to address and withstand such challenges. He set his pen down, his attention returning briefly to the documents before him, then back to the room. This changes the scope of the argument, he said, simply. And that was all. No elaboration, no emphasis, just a statement of fact. But it was enough. Rachel's attorney nodded slowly, his posture composed, but no longer assertive. He understood now that the argument he had prepared was no longer the one being evaluated, that the foundation had shifted, and with it, the direction of everything that followed. Rachel finally leaned back in her chair, not in control, not in ease, but in recognition. Her eyes moving briefly across the room before settling forward again, and for the first time since this began. There was no calculation in them, only the quiet awareness that something had moved beyond her reach. David remained still, but his posture had changed, not rigid, not uncertain, but grounded in a way it had not been before, as if the weight of what he now understood had settled him rather than unsettled him. I remained where I was, my hands resting lightly together, my posture unchanged, because there was nothing to adjust, nothing to correct. Everything that needed to be established had already been placed into motion long before this room, long before this moment, long before the first word of accusation had been spoken. And as the judge prepared to move the proceedings forward, outlining the next steps with the same calm precision that had guided everything thus far, I realized that this was not the moment of victory, not in the way people imagine it. There was no release, no shift in emotion, no sense of something gained. There was only the quiet recognition that what had been built had held, exactly as it was meant to, and that holding, steady and unbroken, had changed everything. The judge's statement did not close the case, but it closed something far more subtle, the version of reality that had been carried into that room by Rachel and reinforced by David. And as the proceedings shifted into a quieter phase, focused now on procedural next steps rather than contested narratives, the atmosphere changed in a way that was almost difficult to describe. Not lighter, not heavier, but clearer, like a window that had been wiped clean without anyone noticing exactly when it happened. Rachel no longer leaned toward her attorney, no longer whispered or adjusted her posture in quick, controlled movements. She sat still, truly still now, her hands resting flat against the table, her gaze fixed forward, and for the first time since this began, there was no visible attempt to shape what was happening around her, only the quiet absorption of it. Her attorney continued to take notes, but the pace had slowed, his movements more measured, less reactive, as if he were no longer trying to steer the situation, but to document it as it unfolded. David remained beside her, but something had shifted in the space between them, not physically, not in distance, but in alignment. He no longer mirrored her posture, no longer leaned in her direction. He sat upright, separate, his attention moving between the judge, the documents, and occasionally, to me, and each time our eyes met, there was less uncertainty and more understanding, not complete, not resolved, but present in a way it had not been before. I did not respond to it, not outwardly, because this was not a moment that required reconciliation, it was a moment that required recognition. The judge began outlining the procedural steps that would follow, his tone consistent, his words precise. The court will proceed with a comprehensive review of the submitted materials, he said, including the structure and its activation conditions, as well as the claims presented by the plaintiffs. He paused briefly, then added, however, any further argument must now operate within the framework that has been established. There was no emphasis on that last sentence, but it carried weight, not as a warning, but as a boundary. Rachel's attorney nodded, acknowledging the direction. His earlier assertiveness replaced by a quieter, more contained focus. Rachel did not move, did not respond, and in that stillness, I saw something that had not been there before, not defeat, not yet, but the absence of control, the space where control had been assumed and was now no longer guaranteed. David shifted slightly in his seat, his hands moving apart for the first time, resting separately on the table, a small change, but one that reflected something larger, a separation not just in posture, but in perspective. I remained where I was, my hands resting lightly together, my posture unchanged, because there was nothing to adjust, nothing to reclaim. Everything that needed to be established had already been placed in motion long before this moment, and now, it was simply continuing, unfolding at its own pace. The judge concluded his remarks for that session with the same calm precision that had guided the entire proceeding. We will reconvene after the review has been completed, he said, and with that, the formal portion of the session came to a close. Chairs shifted, papers were gathered, quiet conversations resumed, but the tone of those movements had changed. There was no urgency, no sharp edges, only a steady, deliberate motion, as if everyone in the room understood that what had just occurred could not be undone by anything said afterward. Rachel stood slowly, her movements controlled but no longer fluid. Her attorney spoke to her quietly, outlining what would come next, but she did not respond immediately. Her gaze remained forward for a moment longer, then shifted briefly, not to me, but somewhere just past me, as if recalibrating her position within a space that no longer aligned with her expectations. David stood a moment later, his movement less restrained, more natural, and for a brief second, he hesitated again. The same hesitation from earlier, but this time, it was different. Not uncertainty about where to go, but awareness of where he stood. He looked at me then, directly, and there was no avoidance in it, no deflection. Only a quiet acknowledgement that did not ask for anything, did not expect anything, and I met it with the same calm presence I had carried throughout, not as an invitation, not as a rejection, but as a simple recognition that something had changed, and that change did not need to be spoken to be understood. Daniel gathered the remaining documents beside me, his movements efficient, precise, and as we prepared to leave the table, he glanced at me briefly. "You handled that exactly as needed," he said, his tone steady, not congratulatory, but affirming. I inclined my head slightly, acknowledging the statement without expanding on it, because there was nothing to add, no need to define what had already been demonstrated. We stepped away from the table, together, moving through the quiet flow of the room. And as I reached the exit, I paused for just a moment, not out of hesitation, but out of awareness, looking back once, not at any one person, but at the space itself, the room where everything had been brought forward, examined, and placed into alignment with what had always been there. And in that brief pause, I felt something settle within me once more, not relief, not triumph, but completion, not of the case, not yet, but of something internal. Something that had been waiting not to be proven, but to be seen. And as I turned and stepped out into the quieter hallway beyond, I understood that whatever came next would no longer be shaped by what had been claimed, but by what had already been established, and that distinction, quiet and steady, was enough. The hallway outside the courtroom felt quieter than it should have, not empty, but distant, as if the sounds of the world had been softened just enough to let everything that had happened settle into place. Daniel walked beside me, without speaking for a few steps, not because there was nothing to say, but because he understood that not every moment needed to be filled with words, and I appreciated that more than I could have explained. The weight I carried was not heavy, not in the way people imagine. It was steady, like something finally set where it belonged. "We will know more after the review," Daniel said eventually, his tone calm, practical, already oriented toward what came next. I nodded once. Not because I needed reassurance, but because I recognized the rhythm of the process. This was not the end, not formally, but something had already concluded in a way that did not require a final statement. We reached the exit doors, the light from outside cutting through the quiet interior, and for a moment, I paused, not out of hesitation, but out of awareness, because stepping out meant leaving behind the space where everything had been examined and entering one where nothing needed to be proven anymore. Daniel gave a small nod before continuing on, leaving me to that moment alone, and I stepped outside, the air cooler than I expected, carrying that familiar mix of movement and stillness that only exists in places where people pass through without staying. I stood there for a second, adjusting nothing, thinking nothing specific, just allowing the shift to complete itself. Behind me, the doors opened again, and I heard footsteps, slower, more uncertain than before. I did not turn immediately, but I knew who it was before I saw him. David stopped a few feet away, not too close, not distant, just enough space to make it clear that whatever this was, it was not the same as before. "I did not know," he said, his voice quieter than I had ever heard it. Not defensive, not rehearsed, just simple. And for a moment, I let those words sit between us, not because I doubted them, but because I understood that knowing and not knowing were not the only things that mattered. I turned to face him then, my expression unchanged, not cold, not warm, simply steady. "You did not ask," I said, my voice even, not sharp, not soft, just precise. He looked down briefly, absorbing that, and I could see the way it settled into him, not as something to argue with, but as something to understand. Rachel did not come out with him, and I did not look for her, because whatever position she held in this moment was no longer something that required my attention. David exhaled slowly, as if releasing something he had been holding on to without realizing it. I thought, he began, then stopped, not finishing the sentence, and I did not ask him to, because incomplete thoughts often reveal more than finished ones. It is not about what you thought, I said after a moment. It is about what you chose to believe without asking why. He nodded slightly, not in agreement, but in recognition, and there was no argument in him now, no attempt to defend the path that had brought him here, only the quiet understanding that it had been his to walk, and his to reconsider. We stood there for a few seconds longer, not speaking, not moving, and in that silence, there was no tension, no expectation, just space, the kind that exists when something has ended but not been replaced yet. What happens now? He asked finally, and I considered the question, not for its surface meaning, but for what it implied, not about the case, not about the outcome, but about us, about what remained after everything else had shifted. Now, I said, things continue as they were meant to. I did not explain further, because the answer was not something that needed expansion. It was something that would become clear over time, in actions, in choices, in what was done next, not what was said in this moment. He nodded again, slower this time, as if understanding that the question he had asked did not have a single answer, and that the answer he needed would not come from me alone. I looked at him for a moment longer, not searching for anything, not expecting anything, just seeing him as he was, not as he had been, not as he might become, and then I turned away, not abruptly, not dramatically, simply continuing forward, because that was the only direction that made sense. I walked down the steps, the rhythm of my movement steady, unhurried, and as I reached the sidewalk, I did not look back, not because there was nothing behind me, but because everything that needed to be seen had already been seen, everything that needed to be understood had already begun to settle. The case would continue, the documents would be reviewed, the final determinations would be made in time, but none of that would change what had already been established, not just in the courtroom, but within me, the certainty Thomas had spoken of, the clarity he had built into something that did not depend on explanation, only on structure, only on time. And as I moved forward into the quiet motion of the day, I understood something in a way I had not before. This was not about winning, not about proving anything to anyone. It was about no longer needing to, about standing in something that did not require defense because it had already been secured long before it was ever challenged. And in that understanding, there was no need for a final word, no need for a closing statement. Only the quiet continuation of a life that, for the first time in a long time, felt entirely my own.